Good afternoon, everybody. Welcome to today's rainy day edition of the live employment law Q&A by employmentlawyer.ca. My name is Teilen Celentano. I'm an employment lawyer and associate with Samfiru Tumarkin, LLP. I work out of our Toronto office and service clients all across Ontario. Feel free to ask your questions directly to me, whether through Facebook, LinkedIn, Twitter, X, YouTube, and I'll answer your questions live. You can also reach out to us at employmentlawyer.ca, by email at help@employmentlawyer.ca, by phone at 1-855-821-5900. And you can get quick answers to any questions you may have at pocketemploymentlawyer.ca. So today I'd like to start by talking about the recent proposed legislation discussed by the provincial government. Specifically, that legislation is the Working for Workers 4 Act. It's a little confusing. It's 4 words, and the whole act is 4 words, and half of them are 4, but it's Working for Workers number 4. And the main crux of this act is aimed at the restaurant industry. So there are 4 big changes that the government is proposing that target the restaurant industry specifically. The first one is they are aiming to eliminate and ban unpaid trial shifts at restaurants. So what that means is a lot of times at restaurants, whether it be servers, line cooks, chef, what have you, will have a trial shift. They'll have one night where they come in, they work for 3, 4, 5, 6 hours, however long, and it's a tryout. They won't get paid. They won't be compensated in any way for that evening. That technically had already been illegal for a long time. For a long time, the law said if you work, you have to get paid. But as part of introducing this legislation, the government is hoping that any ambiguity that may be there is eliminated. Something similar, unpaid internships in Ontario are almost always illegal. If you're working in an unpaid internship, you're almost always entitled to money, and you can file a complaint. You can reach out to us so we can help you file a complaint with the Ministry of Labor to get that money. The second thing is wage deductions. Employers for a long time, restaurant owners that is, have been punishing the servers when their customers or would-be customers dine and dash, or more recently, gas and dash, right? Taking takeout without paying. Again, employers have never been allowed to deduct damages or losses for theft from an employee's paycheck, but they were doing it anyways. So again, this new law is aimed at making sure any ambiguity that exists in that regard is completely removed. The third change is tip pooling. So with tip pooling, it's when they're meant to pool. Restaurant workers and servers are meant to pool their tips into one pot and then split it evenly. Now, if you're going to have a tip pooling policy, it needs to be posted in the workplace. That way, the servers can understand how their tips are being calculated, and they can also understand how much they're getting paid. One other thing that's being highlighted in this process is not necessarily a change to the tip pooling process, but instead they're highlighting again, tips can only be pooled amongst people who do the same work, right? So servers, you can tip pools amongst servers, but managers can't participate in the tip pooling if they're not serving tables. Again, based on the legislation, cooks tips shouldn't be pooled between cooks and servers. They do different jobs. The tips should be separate. The final change to the restaurant industry is with respect to digital payments. So in recent years, as apps and phone apps have become more and more popular, what restaurants have been doing is they've been depositing their tips into a tip app. And then once it's in there, the app itself distributes the tips to the servers, and then the servers pull it out of the account. But what's happened is those apps are charging a service fee to servers. So in addition to the taxes they're already paying, in addition to all the pools, the money they're sharing, these servers are now being forced to pay a service fee every time they go to access their tip. It's like it'd be akin to every time you got a paycheck from your boss, whatever company issued the paycheck, whoever made the pay stub, they also took 1%, 2%, 3% of your after-tax income. So what the new law is going to stipulate is that the employee, the server, can specify what account they want to have their tips deposited into. that means they could say, I want my tips deposited directly into my personal bank account. In addition to those 4 changes, there's a couple other ones that are being introduced. The first is a salary disclosure obligation. So pursuant to this, employers would have to specify what the salary is expected to be for any job posting where that expected salary is less than $100,000. There may be some room for employers to get away with stuff if it's total compensation, not just base compensation. So if, with short-term incentive plan and bonus plan and long-term incentive plan and RSP contributions and base salary, the law sounds like it's going to be ambiguous, but if all those elements of compensation add up to more than $100,000, then it's likely that that this obligation wouldn't apply to them. So there's quite a bit of ambiguity. And then the last big one is with AI. Employers who use AI to screen during any part of the recruitment process, whether it's to screen applications or to help them pick people or run tests or whatever it may be, they're using AI. It needs to be disclosed to the applicants. It's not clear what teeth that part of the legislation is going to have and what AI exactly means, but it's what's been tabled. So that's the Working for Workers 4 Act. I don't know if there's going to be a Worker for Workers 5 Act, but I guess only time will tell. Jumping into your questions now. Again, if you have any questions, I'll answer them live. Just ask them through Facebook, LinkedIn, X, YouTube, wherever you're watching, or go to our website at employmentlawyer.ca or shoot us an email at help@employmentlawyer.ca. So our first question today is from Lily, and Lily asks, what can you do if your employer lets you go while you're preparing to go on a sick leave? So Lily, it depends on it depends on whether or not the company knew that you were preparing to go on a sick leave. So first and foremost, employers in Ontario generally have the right to terminate employees. The wrongful part of a wrongful dismissal is not the terminating of someone, but it's not paying them enough severance. Or enough payment in lieu of notice of termination. Where your case can get tricky is whether or not the company knew or ought to have known that you were about to go on a sick leave and whether or not that knowledge had an impact on their decision. So if it was a situation, Lily, where you told your employer, say, hey, I just got back from the doctor's office. Now have this, and I'm going to need to go on a prolonged sick leave. And then a day later, the company lets you go. Well, there's a very strong argument that the temporal nexus, the timing between when you told them and when you were let go, there was a result. And if a court rules that even 1% of your termination was the result of a disability, then you will be entitled to not only severance, but additional human rights damages. The severance package in Ontario ranges from as little as 2 months to as many as 24 months, and it depends on the individual circumstances of your employment. But Lily, in short, if they knew that you're about to go on a sick leave and let you go in an effort to avoid accommodating you, you're not only entitled to severance, but you're also entitled to additional monies for breaches of the Ontario Human Rights Code. Those same protections extend beyond just a sick leave. There are a number of protected grounds under the Ontario Human Rights Code: disability, family status. So if you needed to go on a parental leave, right? Not maternity. So it applies to both fathers, mothers, and anybody else, guardians, people adopting. There is also gender expression, gender identity, race. There are a ton of protected grounds in Ontario, and companies are not permitted to treat you any differently for any of those characteristics that you may have. Ja Rule 6839. I hope it's not about Fire Festival, but he asks, what about persons who were terminated because they didn't take the vaccine? Are they entitled to any severance pay? So this is a situation that is still unsettled, right? So there are a number of lawsuits that are trying to decide whether or not those people who were terminated for not taking the vaccine are entitled to severance pay. There's no case that has definitively decided it. As I'm sure you can imagine, that was a new issue that the courts are being faced with. My personal view and the view of my colleagues is that yes, they are. That getting the choice not to get vaccinated is a personal medical decision, and that your personal medical decisions are not the business of your employer. And that while that is our opinion, and that has been throughout the whole vaccine process, it's still unsettled. We still don't have a definitive case, but relying on past decisions and relying on past case law, we believe that yes, people who were terminated as a result of their decision not to get vaccinated are entitled to severance pay. They're entitled to a full severance package. If you don't know, if you want an estimate of what your severance may be, you can go to our website and use a severance pay calculator, and it can give you a good estimate of what you may be entitled to in the event you are let go or you were let go. And you can also reach out to us at employmentlawyer.ca. One of the careful things to pay attention to, though, here, Ja Rule, is generally in Ontario, you have a 2-year limitation period for starting a lawsuit. So from the date you're terminated, you have 2 years to start a lawsuit for severance. And that it's not just for severance; it's for any area, any lawsuit. You have 2 years. It's a 2-year limitation period. A lot of the people who were let go for that choice not to be vaccinated, that happened in the spring, in the summer of 2021, right? We're obviously in November of 2023, we're over halfway done it. So we're getting close to the point where most of the people who were terminated for not getting vaccinated, their limitation periods have expired. And while that means that they can't start a lawsuit now. So if you are in that situation, you're in a situation where you were let go because you were not vaccinated, it's extremely important that you reach out to us right away. Schedule a time to speak with one of our legal reps as quickly as possible. If you're outside that 2-year period, there's very little we can do, and that's one of the biggest, most important deadlines in law. There's some drop dead dates that are very strenuous, and there are others that aren't. That 2-year limitation is one that's really tough to overcome. Next question from Lisa on Facebook. I was fired in August of 2019. I worked for the company for 21 years. I was fired because I was on leave. They wanted me to come back and I was not ready to. My question is, am I entitled to severance pay? They ended my employment by sending me a letter and ending it there. Well, Lisa, this is the issue I was just talking about. It's more than 4 years since you were let go. So while it's still worth reaching out to us and seeing if there's anything we can do, that general 2-year limitation period will make things difficult. If you work somewhere for 21 years and you're let go, especially while you're on a medical leave, then yes, you're entitled to something. You're entitled not only to your minimums under the Employment Standards Act, which depending on the size of your company can be anywhere from 8 weeks to 29 weeks. You'd be entitled to an enhanced severance package. Someone like you could be entitled to as much as 21 or 24 months, So yes, you would have been entitled to severance pay. And it's important that in the event that you reach out to us now, in the event that something similar ever happens in the future, you reach out to us. I'm not sure what we'll be able to do, given it's been 4 years and 3 months since you were let go, but still give us a call. There may be something we can do to help you out, but candidly, it may be difficult. But this question also highlights the importance of reaching out to a lawyer, right? There are a number of pitfalls in employment law. Employment contracts are written ambiguity, they're ambiguity, and they're not clear. Ambiguous. There we go. They're written ambiguously, and it's difficult for people to ascertain what exactly it means. And oftentimes, people will assume that if I read a contract, it's enforceable. My employer's following the law. Unfortunately, that's not often the case. Oftentimes, whether on purpose or through negligence, employers write contracts that are far too broad and give employees less than they would be entitled to at law. And we have a number of arguments we can use to get around and have those contracts thrown out. So if you're ever let go, if you're ever asked to sign a new contract, whenever you're starting a new job, it's really important to speak to a lawyer, an employment lawyer, employment lawyer from our firm, who can help guide you and help explain what everything means, right? So if there's ever a substantial change, if you're asked to sign a new contract, if you're let go while on a medical leave, reach out to us at help@employmentlawyer.ca, and one of our lawyers will be able to help you out. EQ asks, I've been put on light duties at work to accommodate my medical issue. My employer has drastically cut my hours, stating they don't have enough work to accommodate me. Can they do this? Well, EQ, employers have a duty to accommodate someone up to the point of undue hardship. And what undue hardship is it's a moving bar. It's not the same for every company, but generally speaking, the bigger the company, the harder it is to establish undue hardship. Undue hardship is more than just inconvenience. It's more than just increased costs, and it's more than just a loss of efficiency for the worker or for the company. They have to show that accommodating you and providing you this work would jeopardize the company. So if giving you these extra hours would put the short-term financial viability of the company at risk, then that there's a chance that they have undue hardship, but it's extremely unlikely. Generally, if you're ready to come back and a doctor has given you orders and says these are the light duties you need to do, then that's what the company has to do. They don't have to go out and create a new job for you, but they have to find all the things that you can do and also look to see if there's other things that you can do, right? So it doesn't necessarily just mean in the context of your own job. They can even give you jobs outside of your past job description to give you the full-time hours. So if your employer is cutting hours and it's really starting to eat into your earnings, give us a call. There is a chance that because the company is not accommodating you, we can trigger what's called a constructive dismissal. A constructive dismissal is treated as a normal termination, in which case we could pursue a full severance package for you worth as much as 24 months pay. So give us a call, reach out to us. One of our lawyers will be able to help you out and really tell you what we can do in your case. My employment contract says I must be available to work at any time, 24/7, 365. I've been in my position on day shift for 17 years. If I switch departments to change jobs, that could mean I end up on a grave shift. Can my employer do this? So technically, if you're on call, you should be getting paid 24/7, 365. But that point aside, if you want to change positions within your own company, right? So you want to go from accounts payable to accounts receivable. You want to go from logistics to internal operations. If you want to make that change, then making that change, the company says you have to making that change, you have to change your hours, then yes, they're allowed to do that. But what the company can't do is if for the past 17 years, right, you've been working the day shift, you've been working 9 to 5, 8 to 4, 7 to 3. And then now all of a sudden, without you initiating it, they say, okay, Kathy, we're going to change your shift from 10 p.m. to 6 a.m. They could not do that, right? So that's the difference. If you're initiating the change, right, you're the one deciding that, hey, I want to change departments. I want a new challenge. I want a new role. And then because of that change, you have to change your hours, then yes, they're allowed to do that, right? You don't have an obligation to move within the company. You don't have an entitlement or right to move within the company and keep the same hours, even though that is generally what happens. The only time we can do something and trigger a constructive dismissal is when the company is unilaterally changing your hours. They're the ones coming in and saying, you're no longer working the day shift. You're now going to work the grave shift. So if the company makes that change, that can be a constructive dismissal. If you decide to make that change, it's a decision you're making. So it is not a constructive dismissal. But, it really depends on who's starting it. In a case like yours, who wants the change? If it's you because you want a new challenge, you've been in the same role for quite a while. Maybe you want a raise, maybe you want new advancement. If that is to happen, it's a new job. And while your past 17 years of service would be recognized for all purposes, you don't have the right to keep those same hours. IMJ from YouTube asks, is it right that the employer reached out to me to ask the following? Someone from early prevention return to work wants to contact me and inform me of the steps of the return to work and help me. So I think what you're asking, IMJ, and correct me if I'm wrong, but is it okay while you're on long-term disability that somebody from the company reach out to you in order to discuss a return to work? So the company has a duty to return you to work. And if and yes, it's okay for them to reach out to you and say, you've been on leave for quite a while. We'd like you to fill out this form in order so we can see if we can bring you back to work. That's absolutely something they can do. Now, that doesn't necessarily mean they will have a job, but they actually do need to make efforts. Similarly, you have an obligation to work with them, right? If you send them a doctor's note that says, IMJ won't be able to work for the next 2 years as a result of XYZ, then the company can't continually harass you and badger you for more and more updates. That's against the law. But merely asking you for an update or saying that, our internal return to work specialist wants to reach out to you to see if we can bring you back to work, that's totally okay. You can also ask that your doctor or your physician or your specialist complete what's called an FAF, a functional abilities form. There are a ton of different functional abilities form. The federal government has one, the provincial government has one. Most big employers have their own as well. And what those documents do is they try to ascertain, all the different things you could do. Can the person lift from floor to knee? Can the person lift from knee to waist, waist to shoulder, above head? If they can, how much? Can they do repetitive bending? Can they do jobs where they have to walk? Can they climb ladders? They're very expansive, and they're forms that your doctor fills out. And once that form is filled out, the employer and their return to work specialist or someone in their human resources department can then look at the form and say, okay, based on these restrictions, we have these 3 jobs that IMJ can do. Or they could say, based on these restrictions, there's nothing IMJ can do. So in a case like yours, the short answer is yes. It's okay for them to reach out to you. It's appropriate. They can't harass you. They can't bully you. They can't badger you, but they're allowed to politely and cordially reach out to you. You similarly have an obligation to politely and cordially respond and cooperate in the return to work process. If the return to work process bears no fruit, that's nobody's fault. It's nobody's fault most times when someone becomes disabled. It's just unfortunate. And it's just the way life goes. But in those cases, again, you do have to comply and work with the company. Michelle on Facebook asks, can my employer force me to work from home permanently? I worked for Teleco and I've never worked from home. I don't have any appropriate space in my house for doing the job. So Michelle, working from home permanently it would be considered a significant change to the terms of your employment, right? So, of course, before COVID, work from home was a luxury that most people didn't have. For me, obviously, I'm working from home today, but it's a luxury that most people didn't have pre-COVID. Since COVID hit, COVID changed the game, right? And it changed the rules surrounding employment law. And people were forced to work from home because of a virus, right? But just like employees can't now say, I'm never going back into the office, employers can't say we're closing our offices down and you have to work from home full time. If they do say that and you don't want to do that, it's likely that change is a significant change to the terms of your employment and you can pursue a constructive dismissal. Said that word a lot, so I'll break it down a little bit more, but a constructive dismissal occurs at any time when an employer makes a significant unilateral change to the terms of someone's employment. So they make a big change without consulting the employee, without asking for the employee's consent or authorization. And that change in the eyes of the court shows that they no longer intend to be bound by the original terms of employment. So in a case like yours, Michelle, where you worked in office pre-COVID, maybe you worked, even if you worked from home a bit during COVID, you did it because it was COVID. But now they're saying we're never coming back to the office. It's possible that it's possible that you'd be able to trigger a constructive dismissal and pursue a full severance package. Where the trick comes in though is whether or not you've accepted or acquiesced to that change. What the case law says is when someone accepts or acquiesces to a significant unilateral change, that then becomes an implied term of their contract and they can't pursue a constructive dismissal. The way that applies to you, Michelle, is if they said, during COVID, March 2020, everyone works from home, right? And then 2 years later, it's in April of 2022, they said, COVID has kind of died down a bit, but we're sticking with the full-time work from home policy. We've sold our offices. No one's ever coming back again. And now here we are in November of 2023, right? Year and a half later. At this point, if you've been working from home for a year and a half, you likely wouldn't have an opportunity. It'd be difficult to win constructive dismissal case because a court would likely view that you have accepted the change through your actions and through continuing to work for a year and a half. So in a case like in a case where an employer makes a significant change, whether it's working from home, whether it's placing you on an unpaid layoff for the first time in your employment, changing your hours like we saw earlier, whenever an employer makes any significant change like that, it's extremely, extremely important that you immediately reach out to a lawyer. Those lawyers will be a lawyer with us. You can get it. You can call us at 1-855-821-5900 or go to our website at employmentlawyer.ca. But whenever there's a significant unilateral change, it's extremely important that you reach out to us as soon as you can. There's no bright line, there's no drop dead date, there's no specific amount of time in which you have to object to the change, but you have to do it quickly. And the longer you wait, and the longer you wait before reaching out to a lawyer and saying, hey, I don't want to do this. I don't want to work from home. I don't want to be on an unpaid layoff. The longer you wait, the worse your case is. So, Michelle, in a case like yours, reach out to us. One of our lawyers will be able to help tell you whether or not you have a case, and tell you whether or not you have a case, and if that's, and what our options are. IMJ followed up and regarding the accommodation issue, and she says they refuse to accommodate me for my light duty because they don't have a light duty to give me. Government employer. So IMJ, it depends on what your job was before, how big the workplace is. But whenever a company refuses to accommodate someone, there is a chance that there's been a constructive dismissal. So in a case like that, reach out to us. Go to employmentlawyer.ca, schedule a time to speak with one of our legal reps, and one of us will be able to kind of get a full synopsis of the situation and tell you what exactly your rights are. There's a very real possibility that they did it in refusing to give you light duty work, that there's been a failure to accommodate, and thus a constructive dismissal. But that isn't always the case. Also, IMJ, it's important that as you said, you're a government employer. You work for a government employer, or you worked for one. Having grown up in Ottawa, I do know that a lot of government employees are unionized. One of the important things to highlight is the distinction between employment law and labor law. I'm an employment lawyer. I work exclusively with non-unionized employees, right? So employment laws representing non-unionized employees. We do have lawyers who practice labor laws, so still reach out to us, but we will be limited in what we can do if you are a unionized employee. So my last question for today from Glenn on Facebook. I've signed a confidentiality agreement when I started my job with my employer 18 years ago. Within this agreement, they said if I quit, I could not work in my field of work for 5 years. Would this agreement be voided if they fire me, or would this 5 years be included in my severance? So Glenn, it's a confidentiality agreement, that sounds like a non-competition agreement. So a lot of people heard that about a year and a half ago. It's actually in the Workers for Workers 1 Act, I believe. I may be wrong, but I think it was in the Workers for Workers 1 Act that the provincial government banned non-competes. Now that it came out afterwards that ban on non-competes didn't apply retroactively. But that said, under the law, under the common law, right, our courts had already said that non-competes were a restraint on trade and prima facie. So on their surface, the presumption was that they were unenforceable. So, and if they are to be enforceable, there needs to be a very succinct temporal restriction, so timing and geographic restriction. And there also needs to be a compelling business interest to protect. So if you're in, let's say, software sales, and they say you can't work in software sales for 5 years following your employment anywhere in the country. I can't say for sure, but I'm very confident that non-competition clause would be unenforceable. The vast majority of non-competition clauses are unenforceable. So in the event that you are ever fired, reach out to one of our lawyers, but it's very likely that the advice will be this, the non-competition clause doesn't matter, it's unenforceable, and we're still going to sue for severance. So, don't take that advice without speaking to one of our lawyers. It's always important to get individualized, one-on-one advice with one of our lawyers, but it's likely that it's unenforceable. That's my time for today. Thank you everyone for joining today's live employment law Q&A. Again, my name is Teilen Celentano, and if there's anything you missed, any questions you wanted to ask, you can email us at help@employmentlawyer.ca. Go to our website at employmentlawyer.ca or give us a call at 1-855-821-5900. Thanks. Hope you guys have a great day.